Good afternoon, friends. This video on one of the important judgment coming from Honorable Supreme Court in the case of Bharti Airtel. Honorable Supreme Court has set aside Delhi High Court judgment which has allowed the GSTR 3B for the period July 17, August 17 and September 17 can be amended, and due to amendment Bharti Airtel is entitled to get the refund of 923 crore paid through cash. So with this amendment, they are being allowed that they can use the credit for discharging their output tax. So whatever they have paid through cash, that should be once again recredited in in-cash ledger and refund is permissible. That was Delhi High Court judgment. Honorable Supreme Court has set aside this Delhi High Court judgment. Listen to the fact of the case. When GST got introduced, it was envisaged there would be automated GST return system for ITC matching and mismatching. Supplier going to file GSTR 1 for the outward supplies, going to be auto-populated in GSTR 2A for the recipient. Recipient can check, verify, and he can do add, modify, delete such particulars while finalizing his GSTR 2. And once he finalizes GSTR 2 and do any kind of add, modify and delete, that gets auto-populated in GSTR 1A for the supplier either to accept or reject. And thereafter a consolidated return GSTR 3 need to be filed under section 39 of CGST Act. This was automated return system. But what happened? You know that government could not implement GSTR 2 and 3, and as a stopgap management, they have only implemented GSTR 3B in lieu of GSTR 3. So as on date, we all are filing GSTR 1 and GSTR 3B. As far as credit is being concerned, it was supposed to be auto-populated in GSTR 2A, which came in September 2018. Even for the period July 17, August 17 and September 17, for the impugned period, we are referring in this judgment. So GSTR 2A came in September 2018. Having said that, what is the fact of the case? Bharti Airtel, being a telecommunication company, was centralized registered under service tax regime. When GST got introduced, they have to take registration in different state where they are operating. Now whatever Sanbit credit was lying in pre-GST era, that is allowed as a credit also in GST regime. So this is the position when transition has taken place from pre-GST service tax regime to GST regime. Now what happened for initial 3 months, July 17, August 17 and September 17? They could not ascertain their credit. They could not determine their credit available to them because GSTR 2A was not into the picture. So they have paid the liability, their output tax, through cash, which they could have paid through credit also had it been known to them. That is the crux of the matter in this judgment. So Bharti Airtel ने इन 3 महीने के लिए जुलाई, अगस्त एंड सितंबर 17 अपनी लाइबिलिटी कैश से पे की टू द एक्सटेंट ऑफ 923 करोड़. क्रेडिट असर्टेन नहीं कर पाए, GSTR 2A नहीं था. सो जब क्रेडिट असर्टेन नहीं कर पाए बिकॉज ऑफ GSTR 2A was not available, they have paid the liability in cash. Now in a given situation, they wanted to amend their GSTR 3B for the month of July 17, अगस्त 17 एंड सितंबर 17 दो सर्कुलर आए. पहला सर्कुलर dated 1st of September 2017, and this circular is referring that if you want to amend your GSTR 3B, you can amend for the same tax period, provided they have implemented automated GST return system like GSTR 1, 2A, 2, 1A and 3. Had it been implemented, then as per this circular dated 1st September 2017, Bharti Airtel could have amended their GSTR 3B for that respective month. अगर जुलाई 17 में गलती हो गई तो आप जुलाई 17 का GSTR 3B amend कर सकते हैं, rectify कर सकते हैं. But you know that government could not implement automated GST return system. GSTR 2 and 3 was kept in abeyance. As a stopgap management, they have introduced GSTR 3B in lieu of GSTR 3. So another circular came on 29 December 2017. And this circular was referring, if you want to amend your return, then you cannot amend your return relevant tax period. You can always do such amendment in subsequent month return. For an example, अगर July 17 में, if you have made mistake and you want to amend it, so you can't amend your July 17. You can do all this amendment in subsequent month return. So मान लीजिए अगर दिसंबर 2017 में आपको मालूम पड़ा कि जुलाई 17 में आपसे कोई गलती हो गई है, तो आप दिसंबर 2017 में amendment entry डालिए. That is the circular dated 29 December 2017 is being saying. Now, this circular was challenged by Bharti Airtel, and Bharti Airtel has said that we are allowed, that we can amend the GSTR 3B of respective month, July 17, August 17 and September 17. But since automated return system was never implemented, government has issued another circular, and as per this 29 December 2017 circular, they are saying you can only put amendment in subsequent month return. Point of dispute. Now, what happened in this case? Bharti Airtel, since they could not ascertain their credit because GSTR 2A was not into the picture for the respective period July 17, August 17 and September 17. It only came in September 2018. They pleaded before Delhi High Court, my lord, I should be allowed to amend my GSTR 3B of July 17, August 17 and September 17. And because of this amendment, whatever I have paid through cash, I should be allowed to pay through my credit account, which is available to me, because GSTR 2A, which came in September 2018, showing me that this credit is available. So I should be allowed that I can pay my liability through e-credit ledger, and whatever I paid through e-cash ledger, 923 crore, it should be refunded back to me. Honorable Delhi High Court has allowed the refund of 923 crore by way of amendment of GSTR 3B of this impugned period. Now, Honorable Supreme Court, and that is what the eye-opener for all of us together. Honorable Supreme Court is saying that GST is a self-assessment tax. Service tax, there was no ITC matching or mismatching. But GST is a self-assessment tax wherein you are supposed to determine your output tax as per section 9 chargeable section of CGST Act or section 5 of IGST Act. You need to determine your output tax. And you can avail credit as per section 16 of CGST Act and pay the liability. For payment of liability, either you can pay through e-cash ledger or through e-credit ledger. Now, you could not ascertain your credit in GST regime for this impugned period, July 17, August 17, and September 17, and which you were doing in pre-GST under service tax regime. Honorable Supreme Court has cast obligation and responsibility on Bharti Airtel. You could have determined your credit as per the law, and you should have used this credit for discharging your output tax. Now, if you are paid through cash, it's a manner of payment. So once you have opted for payment through e-cash ledger, it's just one mode of payment. Since you could not determine your credit correctly, and just because you are arguing that GSTR 2A was not into the picture, the Honorable Supreme Court has said that this automated return GSTR 1, 2A, 2, 1A, 3 is only facility or facilitation, procedural facilitation provided by the government through GST and common network. Since it could not get implemented, it does not mean that you are not supposed to follow the basic concept of determining your self-assessment tax. You must determine your liability. You should avail the credit as per the GST law and should have paid in a manner required to be. So it can be through e-cash ledger, it can be through e-credit ledger. Now you can't come back. That's the Honorable Supreme Court is saying. Now at this point of time, you can't come back and say because GSTR 2A was not introduced for the impugned period, you are supposed to amend your respective month. GSTR 3B is not permissible. You have used your option of payment through e-cash ledger. Now by way of amendment, the return is not permissible. That is what the crux given by Honorable Supreme Court. And Honorable Supreme Court is saying once you have exercised the option of manner of payment, which is through e-cash ledger, by way of amendment of your return, it can't be corrected. Hence, you are not entitled to get refund of 923 crore. Amazing. Try to understand. What Honorable Supreme Court then again saying that availing credit is again your right. You could have taken the credit and you should have used the credit for discharging your output tax. Who has stopped you? Now by pleading that by way of amendment you are allowed, you can use the credit which you have paid through e-cash ledger is not permissible. Now what is the positioning is coming out? Honorable Supreme Court has said GST law has to be followed on the basis of self-assessment tax. Section 9 chargeable section, determine your output tax. Take credit as per section 16. And these return system which is being envisaged, it is only facilities, procedural facilitation, and procedural facilitation to the taxpayer. Otherwise, if credit is available, none is stopping you. You should have taken the credit. You could have paid through your credit account only. Why you have not taken the credit? You were following the same system in service tax regime. So this is the final point which is coming out from Honorable Supreme Court judgment. Having said that, I'm not going into debate whether this Supreme Court judgment is right or wrong, but I can put my point before you, and that is the important one. We have seen a lot of notices are being issued to the taxpayer on mismatch of credit taken in GSTR 3B versus GSTR 2A. We are getting a lot of notices in the market. Department is issuing such notices. I'm finding this Supreme Court judgment is now helping us and saying that this GSTR 2A is only procedural. Facilities or procedural facilitation as provided through GSTR 2A is not compulsory. If you are satisfying the condition as provided under section 16 of CGST Act, you can very well avail the credit. So if for condition under section 16 subsection 2, if you have satisfied, credit would be available irrespective of fact it is coming in your GSTR 2A or not. So that the period prior to this GSTR 2A, which came in September 2018, and period post GSTR 2A, we all can debate. If I'm a buyer, I need to satisfy 4 conditions. What are those 4 conditions? As a buyer, I should have tax invoice copy. I must have received goods or services. My supplier must have paid taxes. And buyer is regularly filing GST return. So if it is not coming in 2A, which is only procedural, my right to avail credit is not going away if I'm satisfying the 4 conditions. And I can give you the example. There are lot many regions that credit is not coming in 2A, but I'm entitled to. Like any B2B supply captured as a B2C by the supplier, fault of supplier, I'm entitled to avail credit. I've got tax invoice, B2B invoice. Just because wrongly furnished by supplier, my right to credit is not going away. This Supreme Court judgment is now helping me to say that this 2A is only procedural facilitation. My right to avail credit is coming out from the concept of self-assessment tax. Second example, if supplier is wrongly picking up GST number of some other party as against my GST number, it will not come in 2A, but I'm entitled to avail credit. Entitled because I'm satisfying 4 conditions. If place of supply is being wrongly furnished by the supplier, it is not coming in 2A or coming with error, but still I'm entitled to avail credit. Some intra-state supply is wrongly mentioned as interstate or vice versa, may not be coming properly in my GSTR 2A, but I'm entitled to avail credit. So this Supreme Court judgment is providing a basis, a legal backing now. The GSTR 2A is only procedural facilitation. If right to claim credit satisfied under section 16 of CGST Act, I'm entitled to avail credit. And this Supreme Court judgment, which is against Bharti Airtel, is also helping us in the context of so many notices in the market, only for mismatch of credit in GSTR 3B versus 2A. And this e-blocking, you're finding blocking of e-credit ledger, which is happening on the pretext of fraudulent or ineligible credit, just because it is not coming in my GSTR 2A, can again be argued and defended accordingly. So this Supreme Court judgment, I've tried my best to give what is the final point which is coming out from this Supreme Court judgment of Bharti Airtel, how it is helpful for the taxpayer. So I tried my best. Stay tuned for lot many GST update. Thanks for watching. Let's keep in touch, and I'm taking this privilege to wish each one of you happy Deepavali. Stay blessed to you and to all the members in your family. Thank you very much.